teachers. Proud to be joined by Noel Candelaria, who is the president of the Texas State Teachers Association. Yesterday, our two teachers and school employee organizations filed a suit in district court here against Commissioner Mike Morath and the Texas Education Agency regarding the rules that have been promulgated related to Senate Bill 1882. And I'll say a little bit more about the law itself in a minute. But I want to start by really expressing why we're actually not filing a suit, but also doing a press conference today. Because what we are seeing more and more from the Education Commissioner and TEA is a real power grab that it has been characterized by a willingness to go well beyond what the authority given to the commissioner in statute is, and we feel that we have an imperious bureaucrat on our hands. Commissioner Morath has again overstepped his authority relating to Senate Bill 1882. And this is problematic for us because it undercuts authority of local school districts, and more importantly, it harms our members, teachers and school employees. Now, we know in Texas that the legislature has passed carrot and stick laws. 1882 was a response in some ways to a bill that was passed in the 2015 session, House Bill 1842. House Bill 1842 enacted fairly draconian punishments for school districts who have schools that are in need of improvement in multiple years, including forcing those schools to be closed or taking over the entire school board if a school is on the low performing list for 5 years. And Senate Bill 1882 offered some relief to school districts, but it was a carrot with some sticks attached to it. It seems like in Texas we're having a hard time moving beyond the old No Child Left Behind, test and punish frame in our accountability system, right? The federal law on accountability, the Elementary and Secondary Education Act, moved on from NCLB, and states are no longer required to impose draconian punishments on schools and school districts that have struggling schools. Nonetheless, in Texas, just this year, we're seeing the latest rollout of A to F. Couple that with the fact that our state legislature is not providing the required resources to schools, and last session was a classic study in legislative stalemate, where because the legislature couldn't seem to pass some of the pet projects of one chamber of the legislature, everybody lost, especially school kids. And so there's a desperation out there on the part of school districts to get out from under these punitive sanctions and to get the needed resources to serve low-income kids. Enter Commissioner Morath, who really seems intent on bending and breaking the rules to be able to meet his ends. And what do his ends seem to be? Well, he is an unabashed cheerleader for charter schools. It seems like the commissioner sees no harm, no fault in the rapid growth of charter schools, very unwilling to check charter schools that are having problems financially or academically, and very eager to push charter school models down on school districts. The commissioner seems very interested in trying to usurp the power of democratically elected school boards. And we remember that Commissioner Morath made a name for himself as a Dallas ISD trustee when he teamed up with folks in the Dallas area to try to turn the entire Dallas ISD into a charter school district through the so-called home rule law, something that he failed at, but nonetheless seemed to catch the attention of Governor Abbott. Not only has Commissioner Morath in his rule writing around Senate Bill 1882 gone beyond what the legislature has authorized, as he did, I might remind folks, when he rolled out rules on the state's teacher evaluation system, which was the last time that we found ourselves in court with the commissioner, and which ultimately ended in the commissioner making changes so that his rules didn't violate the statute. But in this case, we believe the commissioner actually has enacted rules that conflict with the statute and intentionally seek to undermine protections for school employees and requirements that school districts and charter operators need to satisfy that were intentionally put into the law by the state legislature. So this disregard for the law itself, the overreaching, the claim to authority well beyond what the legislature has granted, are emblematic, we believe, of a troubling pattern of behavior on the part of Commissioner Morath. Hence, we find ourselves in court with him again. I'd like to say a little bit more about the specifics of the suit, but first I'm going to invite my colleague, Noel Candelaria, to come up.
Thank you, Louis. Good morning, everyone, and thank you all for being here. I am Noel Candelaria, a high school special education teacher from El Paso and president of the Texas State Teachers Association, proudly standing here next to my colleague and counterpart with the Texas AFT, Louis Molfaro. We probably wouldn't be here today if our elected leaders had spent more time providing our students and our educators the necessary resources they need for classroom success, instead of tweaking our so-called school accountability system. But Senate Bill 1882 has added a new element to that accountability system, and we expect it will become increasingly popular with school districts because, as Louis stated, it provides some of that extra funding to budget-strapped school districts and helps them avoid sanctions to struggling schools, sanctions that are primarily based on standardized test scores. Commissioner Morath has shown an eagerness to help districts turn over struggling campuses to charters. But we're asking them to not just slow down, but to stop and follow the law. And that is the purpose of our lawsuit. One of the first districts impacted by Senate Bill 1882 was San Antonio ISD, which allowed a neighborhood elementary school, Stewart Elementary, which, by the way, TEA's data last year showed that 1 out of every 3 teachers at Stewart was a beginning teacher. And 82% of the teachers at Stewart Elementary have 55 years or less of experience. And now they're being taken over by Democracy Prep, which is a New York-based charter school. We believe the Commissioner violated a key provision of Senate Bill 1882 and a key provision of his own administrative rule by approving the takeover without requiring the district to consult with the Stewart faculty and staff about provisions of the Democracy Prep contract or to discuss alternatives, such as allowing a local higher education facility to intervene. Additionally, the district and the Commissioner ignored the contractual rights of the Stewart employees by requiring all faculty and staff at the campus to resign from the district and, if they wanted to stay at Stewart, apply for employment with Democracy Prep. The San Antonio Alliance of Teachers and Support Personnel, which is a combined TSTA and AFT local affiliate, sued the school district. But a state district judge in San Antonio denied the Alliance motion for a temporary injunction to block the Democracy Prep takeover. That lawsuit, however, is still pending, and its basic legal issues have not been resolved. Now, we stand here before you suing the Commissioner because we believe he also violated the law when he approved the district's contract with the charter operator, and we are not confident that he will uphold the law in future charter conversions. We have high expectations for our students and our educators, which includes obeying the law. And we should expect no less from our Education Commissioner. Commissioner Morath violated provisions in Senate Bill 1882 that were designed to protect important educational standards for children and essential employment rights for educators. The Commissioner is supposed to be the state's chief regulator of charter schools. As such, must protect students, educators, and taxpayers, and not cut corners for charter operators. Thank you.
Thank you, Noel. So I want to dive in a little bit more before we take questions on the specifics of the suit, and Noel highlighted some of these. So we're aware that the legislature passed Senate Bill 1882 in the last session, and that it provides school districts who enter into a contract with a charter school operator to take over operations at campuses that are deemed to be low performing under the state's accountability measures, and that if the district does so, it can qualify for temporary relief from the accountability sanctions and also gets additional benefits. But the legislature, in doing this, put strings on those arrangements, including specific protections for school district employees on the campus and regulation of the performance contract between the district and the charter school operator. Contrary to the legislative intent, the Commissioner's rules that we're challenging in this lawsuit reduce the number and type of charter operators that must abide by these rules that were put in place specifically to protect public school employees. After 1882 was signed into law, the Commissioner promulgated rules to implement the legislation. The rules went into effect in April. However, little more than a month later, the Commissioner actually departed from his own agency rules in announcing a de facto rule that significantly, as Noel made reference to, limited the safeguards that the legislature had intentionally put in place to protect teachers and other employees in the context of an SB 1882 charter. On May 22nd, 2018, the Commissioner issued a determination that the provisions of the Texas Education Code, section 11.174C, which he had earlier promulgated, designed to ensure that a school district consult with the staff on the campus about the provisions in a contract with a charter operator, and that existing employment contracts not be adversely affected, applied not to all of these charter partnerships, but only charter partnerships with so-called open enrollment charter schools. The Commissioner's determination is a statement of general applicability, which is a lawyer's way of saying it's a rule that will now apply across the board. He did this without legal authority, and he did it without going through the rulemaking process as required. It directly conflicts with his own administrative rules, as well as conflicting with the statute that was adopted by the legislature. There are two other challenges, legal challenges, that we're making to the Commissioner's rules. One is around the issue that the Commissioner has overreached in telling school districts what they can and cannot do in contracts that they enter into with charter operators. Under the Education Code, school districts have had for a long time the ability to adopt in-district charter schools. And an in-district charter is a charter granted to a campus through a negotiation between the operator of the charter and the school district, where the school district gets to negotiate the provisions of that agreement. And in particular, the law says that that the school district and the charter operator have to agree to exempt the campus from local policies that are identified in the contract. The Commissioner has turned this upside down on its head and said, from now on, all policies do not apply, that the starting place for local policies is that they are all waived by the school board, and the school board is not allowed to make additional requirements in these performance contracts. We see this as an incredible overreach of the commissioner, both because the statute gives him no authority to do this, and what he is doing is he is imposing his will, which is to have the equivalent of open enrollment charter schools be the only model that school districts can use. The other authority that the commissioner has given himself is that he has said in his rules that he alone determines whether a proposed Senate Bill 1882 contract will improve student outcomes for the campus, and that he may examine the grant application and choose to impose additional requirements based on this very general will improve student outcomes at the campus. Again, the commissioner is giving himself authority that the legislature never intended to give him. So those are the kernels of the legal argument, and we are ready to answer your questions. We are happy to do one-on-one interviews with you afterwards.
Could you explain what are the next steps? You're basically seeking to stop Morath from doing what he's doing.
So the suit has been filed in court. The plea asks that the rules that the commissioner has promulgated that we believe violate the law be nullified. So the court action would be to strike the provisions in the original rules as well as this new rule that the commissioner essentially issued in dealing with the school, Stewart Elementary School that Noel made reference to in San Antonio, which was closed down, handed off to Democracy Prep Charter, and none of the teachers or school staff were given any opportunity to weigh in. And you know, I have spent time with those teachers and with our local affiliate, as has Noel, and they point out the frustration they feel, not only at a sense of being kicked to the curb, but the disrespect for adults who have been working in a community. To be told, we are moving you out of this school, we are bringing someone else in, and we are not going to talk to you at all about this school, these kids, these families, this leave. But it's also, I think, emblematic of a complete misunderstanding that schools are embedded in communities, and that people who work in schools want to be engaged in talking about how to make those schools be successful. I point to Mendez Middle School here in Austin to give you an example of how a school district did this differently. Mendez also is under an 1882 agreement, also with a nonprofit, and the school district in Austin actually invited several organizations that expressed an interest in partnering to come in and make a presentation to the faculty at Mendez, and then discuss with the faculty what would be the best fit, in your professional opinions, for this school. So there is a reason why the legislature saw fit to not only provide protections in the employment arena, but to say, hey, you got to talk to the people that have been teaching the kids in these communities. You can't just bulldoze over them, which unfortunately is what San Antonio ISD did, and the commissioner gave them the stamp of approval.
And I think just to add to that, what is lost in all of this is the fact that it is still based on standardized test scores, right? And the fact that the number that I highlighted, which is the teachers at Stewart Elementary, who over 80% of them have 5 years or less of experience, what they want and what they've been asking for is support from the district to help them do what's best for students. And instead, they overlooked their needs and their requests, right? And their needs of support and professional training with such a young staff to do what's best for kids. which is what's lost in all of this when we're talking about what's at stake with this lawsuit, is the fact that it's not just Stewart Elementary, but campuses across the state of Texas. When as a state, we have over 1/3 of our teachers with 5 years or less of experience. This is not just unique to Stewart. Dallas ISD, more than 50% of the teachers have 5 years or less of experience. There's been a huge turnover in a lot of campuses across the state because it's all based on standardized test scores. And instead of really going in and talking about what's behind those test scores, what are the actual needs in that community, similar to what we did here at Mendes, that Lewis pointed out, and bring all the stakeholders in and have a conversation as to what is it, what are we going to need, how do we bring all of state, national, local resources together to help lift an entire community and not just shut down the school, turn it over to a charter operator, primarily so based on test scores.
You're kind of hitting on this, but I think I'm still a little confused. What would this mean for the student in one of these schools during a takeover? What would that look like on their end?
Well, I think what we heard early on from the district was that there would be no impact on the student, it'd just be a smooth transition, but anyone knows that the moment you turn it over to a charter operator, the parents now lose that voice and that local control, and the students now fall under a completely different standards, right? And so what it means to the students is the students no longer having full access to their neighborhood public school, because now the charter operator has the ability to say, well, you don't meet our standards, go to the neighboring school. And so the protections for the students, it does not guarantee, when the focus is still primarily on test scores, it's not guaranteeing that we're meeting and addressing the needs of the whole student in that community and all the students in that community. And I think that's what gets lost with all of this is, at the end of the day, the impact that it has on students and the teachers' willingness to work and provide the students the best education that we can when they're with us. But all of this is lost when all we're doing is focusing on test scores and now bringing in external charter operators to take over a school instead of it being from the community, within the community.
And all of this is being done kind of without notifying parents or teachers?
Right.
Yes, in Stewart's example, of course, teachers were notified, but they were notified, you won't be working there anymore. There was very little engagement with the parents. So from a student's perspective, this is what it looks like. I come back to school this year, and none of the adults who I worked with before are in my school. It's a whole cast of strangers that I've never met before. No one knows my name. No one knows what I worked on last year. No one knows my strengths. No one knows my areas where I need to improve. That's all gone. This is a throwback to reconstitution. And the research on reconstitution is pretty unequivocal. It didn't work. Going in and getting rid of all the adults in the school, getting rid of the principal, getting rid of the teachers, and bringing in a whole new team, turned out that wasn't a good strategy. That's not my opinion. That was tried. It seems like Texas is caught in this no child left behind time warp. Like Mike Morath got born 15 years too late. He would have been real comfortable in D.C. with George Bush and Sandy Crest when they were writing the No Child Left Behind law. But we've moved on from that. At least the country has moved on from it, because the test and punish stuff, it turns out, didn't work. Now, if you dig in on Democracy Prep, you're going to find out a couple of interesting things. They just shut down one of their schools in Washington, D.C. Shut it down. It wasn't working. This is the charter model. If the school doesn't work, we just close it up. Those kids can go somewhere else. So if the kids at Stewart don't do well in a year, 2 years, 3 years, is Democracy Prep just going to close their doors? They also have a school in Virginia where over 60% of the kids have been suspended at one time or another from school. This is another one of the MOs of some of these charter schools. They don't want kids who struggle behaviorally, and so they keep kicking them out. So the parent finally says, yeah, I can't have my son at home again today. I'm just going to go find a school that isn't going to send him home every day. So we've actually done some research because the teachers at the school wanted to know, who is this group that's going to be getting all our kids and getting our classrooms and getting our schools. That's who they are. That's who they are. They're not a Texas-based group. They have no experience in this state. They didn't want to offer bilingual ed, which I'm not sure how you get away with doing that, since the Texas law requires school districts that have a certain number of kids that don't speak English as the primary language to provide bilingual education as an option for those students. But so that's what it looks like from the kids' perspective. Not a very appealing model. We'll see how many of the families even come back to the school. Yes?
I have a question from Aaliyah Swati, who can't be here right now, but from the Texas Tribune. And she says that after the San Antonio's Teachers Union lawsuit was dismissed, what makes you think that you can win in court?
Well, no, what we filed was an injunction to basically stop the process, right? And so that's still, that's still pending. So it hasn't been lost, it's still pending. We just wanted to meet an injunction to stop the immediate takeover. And basically, let's slow down, let's go through a process that actually involves the entire community before we go down this road. So that's still in the process in San Antonio.
Well, this suit is a fundamentally different set of issues also. We've mentioned the Stewart Elementary School because it's emblematic of what the wrong way to impose the regulations is. But what we are challenging right now are the commissioner's regulations that apply broadly to all school districts and to any district that does an 1882 partnership. It is the case that in the Stewart situation, the commissioner and his deputy wrote a letter to the school district saying, oh no, you don't have to follow our rules. But we are not challenging the San Antonio 1882 specific case. We are challenging the commissioner saying any school district that partners with an entity that's not an open enrollment charter school can disregard the safeguards that the legislature wrote into the law that apply to consulting with teachers and employees and also providing that they do not suffer adverse effects employment-wise.
Also, Senator Menendez spoke at a school board meeting. He was one of the authors of Senate Bill 1882. And he spoke to the district and basically told them that this is not the intent of Senate Bill 1882. The intent was to actually provide support and resources to struggling campuses to help, not to shut them down and bring charter takeover to come into the school district. Even charter operators that the commissioner has the authority of authorizing that haven't even really been authorized by the state of Texas, right? Because through this process you can bypass the state process and have the district authorize them as an internal operator to now come in through the district as opposed to the state. So there's a lot of things that are wrong with how Senate Bill 1882 is being applied in the state of Texas, which is far away from the intent of actually helping provide support to struggling campuses. And so that's why we're here today.
Thank you.
All right. Any other questions? Thank you all very much for being here. And Noel and I are both available to visit with you after